Welcome to Just Verdicts with your host, Brendan Lupetin, a podcast dedicated to the pursuit of just verdicts for just cases. Join us for in-depth interviews and discussions of cutting-edge trial strategies that will give you the keys to conquering the courtroom. Produced and powered by LawPods.
All right, welcome back to Just Verdicts. Today we are talking with Dave Kwass, who is a partner at Saltz Mongeluzzi Bendesky, and Dave, you and I actually met 6-7 months ago because I knew you as just a stud construction, disaster type attorney, and actually needed to refer a case to you. And so we got to meet that way, and you were super, super cool to me. And it's awesome that now I see you got a great verdict recently and we can sit here and talk on the podcast. So thanks for being here today, man.
Well, thank you so much. I remember that when we first met, I think you were just about to go on trial. You actually got an awesome verdict. And I guess the question is, when Brendan Lupetin gets an excellent verdict, who interviews him?
Me. I get on there and I use this to tout my amazingness and since then have taken some trial losses. It's happened sometimes, and I talk about those as well. It's you got to be totally forthcoming here. But
yeah, we did two in August, and in one of them we came in second place. So I absolutely understand.
Yeah, and nobody talks about those, but I think sometimes, especially for younger lawyers, it's important for them to know that, if you try a lot of cases, you are sometimes, unfortunately going to lose, and, that's sort of an occupational hazard. Obviously, we don't want that to happen, and we love talking about, the epic wins like this case today in Riegel. And one quick little backstory, I don't think I told you this when we were first talking a few months ago. I remember I was in a settlement conference right before trial on a construction accident case. This was probably 6-7 years ago. And I was, trying to get we were conciliating with Judge Delavecchia here in Allegheny County, who I know you have been in front of because, as I'm sitting in there and he loves to tell stories, he goes out of his way to tell me, who's a really good lawyer? A really good lawyer is a guy named Dave Kwass. Do you know who that is, young man? He'd always call me young man. You know who Dave Kwass is? I was like, no. He's like, well, you should. He's a really good lawyer. He's been in front of me a bunch of times. So that's a true story.
Wow.
I didn't know who you were at the time, but turns out he wasn't BSing. So anyway, you're a partner. You've been a trial lawyer for a long time. Tell us a little bit about yourself. What kind of cases do you mostly focus on? What drew you to becoming a trial lawyer?
Well, so those are two things there. Let me try to address them each. In terms of what I am handling, predominantly I am working on catastrophic injury, wrongful death, construction accident type cases. So very generally, most of the cases in which I'm involved either will have some sort of a crane or a large piece of construction equipment tipping over or hitting power lines or otherwise creating some kind of harm where somebody's catastrophically injured or someone is killed. I would say in our practice, Brendan, probably, maybe half the cases or so are wrongful death cases. I never actually meet the client. Probably half survive the construction site accidents that they're in. So it's sort of a mix in that way. The way in which I became a trial lawyer has everything to do with my father's first cousin, Herb Lewis, who was an attorney. He had been an assistant district attorney in Rochester. Then he became a criminal defense lawyer. And whenever he would visit, Cousin Herb would tell us stories about his criminal law practice in Rochester. And he had all sorts of wonderful stories about how one time Jimmy the Bug was unable to pay him and so showed up one Saturday morning with a van full of blue ultra suede jackets and was a little bit surprised and dismayed that Herb didn't want to accept the ultra suede jackets as payment for legal services. So that was something that I think always kind of interested me. I've always identified myself as something of a verbal aggressive, and that is this just sort of seemed to fit as a career path.
Awesome. I guess you sort of knew all along, that influence that, sort of pushed you towards law. I sort of realized later in life a big influence of mine was my grandfather, Edward Pop Sullivan, who later in life, actually, I didn't know exactly what he did until I became a personal injury trial lawyer. And I started thinking back to the stories I heard about him. So, big Irish Catholic family in New York City, and sort of, majorly tongue in cheek, but, only kind of a PI lawyer would say this kind of thing. They would pray before dinner. And then at the end, he would sort of half jokingly have serious say to the kids and pray that dad gets a leg off case soon. Uh,
Oh man,
and I
that's
remember
so
hearing,
wrong.
but I remember hearing that as a kid and not understanding it. And then when I became a trial lawyer, it clicked, and I started laughing at myself about that. So I'll say that sometimes again, you know, mostly jokingly to my kids, just in honor of my grandfather. So,
Yeah,
um,
it reminds me though that for me, I was practicing as a defense lawyer almost 9 years before I kind of figured out really who I was. I mean, so in a sense, I kind of learned who I was professionally and politically, as opinionated as I've always been. I actually didn't even know if I was a Republican or a Democrat or an independent or a libertarian until I was in my 30s. And it was really only when I came to Salts Mongaluzzi that everything sort of came into place for me. I realized, I'm a card carrying liberal. I'm okay with that. I like representing victims, not corporations. That's who I am. I'm good with that. Um, so all of those things kind of came to me eventually, but it wasn't like with respect to that part of it. I knew I wanted to be a trial lawyer and perform, but in terms of what I was called to do, who I was called to help, that part I really didn't learn about myself until my mid 30s.
I imagine when you're working as a trial lawyer on the defense for that long, probably drank the Kool-Aid off the bat, but then something started to change over time, or were you always kind of like, I'm not sure if this is the right side for me? And then, I mean, were there cases or something in particular that started to really click and make you think, I think maybe I should check out the plaintiff side of this?
No, I was always a square peg in a round hole on the defense side. I remember from the very first time that I walked over here in Philly to the Union League and went to a Philadelphia Association of Defense Counsel meeting, that the tone, the tenor of the discussions, the suspicion, I would say, about the truthfulness of plaintiffs and plaintiff lawyers, none of that ever really felt as though it was right. So I was mostly, as a defense lawyer, defending medical malpractice cases. And my predominant impression was I'm winning all these cases because I hustle. I'm winning all these cases in discovery largely by filing a motion to compel expert testimony, then getting a motion for sanctions, and then in short order, getting a preclusion order and getting summary judgment. And what occurred to me was, number one, in a lot of these cases, I was pretty suspicious about my own clients and thinking, I'm kind of thinking there was malpractice here. And I certainly wasn't thinking that the majority, if any, of the cases I was seeing were frivolous. And it also began to occur to me, with my hustle and my energy, my assertiveness, if I were on the plaintiff side and being well funded, I think I could be beating the crap out of the clients that I was representing. So when there was an opportunity for me to make that move, when Mongaluzzi calls me into his office and says, I'm going to make you an offer you can't refuse, I was kind of ready for it.
Awesome. In talking with you before we jumped on, I learned that, well, you've been doing it much longer, but we both are teaching trial classes at local law schools.
Yep.
And, part of what I'm trying to do is impress upon the students kind of big picture concepts of, things that are going to help them, the importance of reputation, the importance of, like you said, hustle, whichever side you're on, and, that hustle factor and so forth. And I'd like to hear, from your perspective, separate and apart from like the nuts and bolts of, how to try a case, what are some of the most, do you feel, important concepts or pieces of advice that you try to give your students?
Definitely, it has to do with individual professional credibility, and sense of personal advocacy. And I mean something very specific by that, Brendan. One of my heroes is Shane Inspector. And there's a particular reason that Shane Inspector is a hero of mine. And that is, I didn't come from a large working class family. I was raised with privilege. I was raised reading and discussing the Sunday New York Times and copying out words I didn't know and trying to get, the highest scores on my SATs and trying to go to elite colleges and all the rest of it. I grew up pretty fancy. I did not grow up with a plastic spoon in my mouth. Shane Inspector said, not just individually to me, but I heard him speak, and this goes back a good 15 years. He said, in what we do as plaintiff lawyers, it is an impediment sometimes to be raised privileged. And it can be a great advantage to be raised without that same level of privilege. So for me, in my personal advocacy, what I am always thinking about and always struggling to overcome is, on the one hand, being who I am, not trying to pretend that I'm a guy who grew up in Northeast Philly in one of the parishes. I didn't, and I can't pass for that. But at the same time, I need to make sure, even if I know a whole bunch of SAT words that you don't know, I don't ever want a jury to feel as though I'm speaking down to them. I don't ever want them to feel, oh, here's rich, overeducated guy using fancy words. I don't even know what the hell he's talking about or what he means, but it feels as though I'm being insulted because of the way that he's speaking to me. And so for me, for my personal advocacy, and this is what I tell my students, for each student, it's going to be a little bit different. But for my personal advocacy, what I have to keep an eye on is, am I both being me, and am I also being careful not to ever talk down to a jury or make anyone feel as though I'm trying to make them to feel small or feel less educated than I am. So that's kind of been my journey. And I share that with students because I want each of them to think about, what is it, if you're going to be a professional persuader, what is it that you need to do to overcome resistance to your personal advocacy, which is, and I'm assuming we're going to talk about this, very, very much like in a case like Riegel, using focus group work to understand what are the parts of my story that are going to meet juror resistance. So what I'm thinking about constantly is, how do I avoid or overcome resistance to my personal advocacy, and how do I overcome any potential resistance to the case or the story that I'm telling?
What you said, resonates closely with me, because similarly, I grew up, privileged. My dad was a doctor and so forth. And I've certainly had those feelings in almost like a weird way, like, I've had it, too easy for this kind of, I'm not quite sure what it is, but, but getting to trial, I look at it very similar to yours. Like you're trying to be mindful of all these things. And I've sort of gotten to the point of looking at it as like, in trial, when you're doing it the right way, you're kind of the best version of yourself. You're balanced, you're credible, you're not above anybody. You're humble, you're straightforward. You're relaxed, but you're kind of checking off all these things of like, this is, if I could be, the best way of myself, those are when I usually get the best outcomes at trial when you're doing that. And it's cool because it's kind of it's something you're striving to always get better and better at trial. That said, and what I've been saying to my students and why I'm a huge believer in focus groups is, and there's almost that aspect of, there's a privilege when you compare most attorneys to society of just having gone to law school. You're different now than a vast portion of society. And I personally find focus groups are so important because they're like a reality check. While I might be on the right point on a lot of the case, I did not see something else. And I tell the students, like, your mind is being reprogrammed right now as you're going through school, as you're sitting here listening to this class. And focus groups are huge just for bringing me back and helping me think of things that I hadn't considered, thinking about how to say things in a more appropriate, way than I might have otherwise done. So, totally agree with you on that.
Yeah, there. If I can, I don't know, maybe jumping ahead. There's a terrific example of that in the Riegel case, which is this. So I guess, right, we haven't really introduced the case, and I don't know if you want to do that, but
This is great. No, I mean,
take kind of a side point.
Yeah, let me just kind of like tee it up. Okay. So I am always scrolling the verdicts that are coming through on different cursors, and I see big verdict comes out, and who do I see's name attached to it but yours, which I was super excited for you about, and also happy that hopefully would get to talk like we are. So the case is it Catherine Hanum?
Yeah, Hannon, yeah.
Catherine Hannon, administrator of the estate of Justin Riegel versus Concert Golf Management and a whole slew of other entities, which I'm really interested to hear how you handled all that, which, in a brief summary, why don't you give us kind of the nutshell and then pivot into the point you wanted to just make?
Okay. A brief summary in the nutshell is that in June 2020, so just over 4 years ago, there was a type of severe thunderstorm called a derecho that struck in, it actually traveled all the way across Pennsylvania, but it struck several places in our area in the northwestern suburbs of Philadelphia, and at a golf club called Philmont Golf Club. Once there was lightning detected within 10 miles of the club cleared the course. The golf professional, Justin Riegel, helped a member to get off the course and into her car, and then drove her cart back to the cart barn at Philmont Country Club. And as he is helping the caddy master get the cart into the cart barn, the storm really kicks up, so he and the caddy master are there, kind of in the door of the cart barn. The winds really begin to pick up, and an 83-foot tall, 36,000-pound oak tree located 23 feet away from the wall of the cart barn topples over, comes through the cart barn, and Justin Riegel is crushed and killed by the impact. So that's what the case is about. And as you pointed out, the administrator of the estate was Kate Hannon. And this raises an issue, Brendan, that I never thought about. It never occurred to me that this was going to be an issue. And when we did our focus group work, we were sort of focusing the case on two theories. One is that the tree should have been removed before this storm had hit. The second was that the weather preparedness program at the country club should have been much more robust. So those were the theories of liability, basically. What had not occurred to me, and I'll say, the focus groups were basically liked the case, basically thought, yeah, probably the tree should have been removed. Yeah, probably the club ought to have been more prepared with regard to bad weather events. Um, but the focus groups were uniform, all 12 or 14 groups that we had. I couldn't believe it. Said, now, what about this? You know, Justin Riegel is a golf professional, and his girlfriend, Kate Hannon, with whom he's having a baby out of wedlock. Um, and all of these questions and suppositions and accusations about golf pros as gigolos and other workers at golf clubs as kind of being sexually available to them, and all this suspicion about Kate. How do we know that that her son is actually Justin Riegel's son? And I'm looking at this, and for not good reasons, we didn't actually get our focus group results until, I don't know, maybe 6 weeks or something before trial. And all of a sudden, I have this massive issue that I had never anticipated. And we had to sort of scramble and figure out how in the world are we going to counteract this area of resistance. I was absolutely dumbfounded. And what we were able to do is, both working with Kate to establish a timeline and a story for it. It turned out there had been DNA testing to establish paternity. A court had accepted that of record, issued an order. And then I think, an important part of addressing it was we had Justin's mom there also. And Kate and Justin's mom, Yvette, continued to be very close. They sat together every hour, every day at trial. We presented testimony that Yvette has her grandson every other weekend for the whole weekend. Yvette goes on vacation with Kate and her grandson and Kate's two girls from a different relationship. So in that way, we kind of tried to counteract a narrative that we never anticipated, which was, how do we know that Justin Riegel's son is really Justin Riegel? And how do we feel about two people who were planning to have a baby, but at that point were not married? Kate told on the stand a wonderful story about how Justin had come to her, very, very much wanted to get engaged, wanted to be married. And Kate sort of said, yeah, look, looking like this, there is no way I'm getting engaged right now. Let's have the baby and then we'll talk. And Yvette, Justin's mom, told a wonderful story about how her son, before he died at age 38, had only had two girlfriends in his entire life, and the second and the true love of his life was Kate. So that's the way in which we kind of scrambled to address that concern. But that's one of those examples of an issue that never saw it coming. And yet I'm thinking it was like 12 out of 12 or 14 out of 14 juries that raised the issue in one way or another.
Did you find, when the juries, before you had recognized this was a real issue, were bringing it up in their deliberations, was it impacting their finding of liability and damages, or just damages? Like what good's the money for, and questions about whether they should give money. But sometimes you see how damages can impact the decision on liability as well.
Yeah, it's a little bit difficult to completely tease that out and completely pull that string, since we didn't have a control, right? There wasn't, another set of juries where we presented it differently. But it did seem as though it was dragging down both liability and damages.
And you knew, if nothing else, it was something you had to answer and bolster in your case, or else it was probably going to hurt you in one form or another.
Absolutely. And I mean, I remember reading the focus group report and thinking about, okay, how can we do this? And I talked to Kate, I talked to Yvette, and then I had this terrible moment of panic. We'd already submitted our witness list in our pretrial memorandum. So I'm like, oh my God, did we even list Yvette as a witness? And without her, without mom talking about her relationship with Kate, with her grandson, how am I going to get this on? And thank God, and I had nothing to do with this. Thank God for my wonderful team that had put Yvette on the witness list, even though she had not had her deposition taken. The defense never deposed her.
So, that was one big issue that fortunately you were able to address in time. But again, when I looked at, this verdict description coming through, it seemed super simple. Big giant tree falls over on Golf Pro, big verdict. Well, duh, of course, I'm sure they had some evidence, but there's all these other really complicating factors in this case. Number one jumps out to you on the caption. There's all these different corporate entities. How does that factor in to the way, the case was tried, problems that had to be addressed as far as, proving up your case?
Well, it had to be discovered, understood, mastered, and simplified, is the very, very short answer. So one thing that we did was to work with a forensic accountant in order to understand better exactly who controlled what according to the way in which the money flowed. And so one of the things that I wound up saying to the jury in the opening statement was, don't focus so much on what you're told about who was controlling this or that. Follow the money, because the money tells you who was actually exerting control. And so what we were eventually able to do was to whittle down the list of defendants to 3. So you have the owner of the property of Philmont Country Club, and the theory there was that they had a hazard on their property. That's kind of straightforward, restatement second of torts kind of stuff. And then there were 2 property managers, but they weren't overlapping. They were distinct in time. So you have one property manager up until August of 2019, and then a different property manager that has taken over since that time. And in the property management agreement, it speaks of an absolute right of control with the property manager. And that wound up being very important because with respect to Concert Philmont LLC, it clearly was the title owner of the Philmont Country Club and its property. And their key defense was that it was immune because it was Justin Riegel's employer. And so the defense was, listen, these management companies, corporate, Concert Golf corporate, really didn't control anything. They were just there to be a resource, provide expertise, provide guidance if asked, but control and all the decisions made about weather preparation and whether to remove the tree, those were all done at the level of Philmont Country Club, and Philmont Country Club was the employer. Hugs and kisses defense verdict. That was what was going on.
And was that a unified defense trying to say that, if there was a defendant, they're immune because they're the employee or employer of the employee in question, workers' comp, immunity, and so forth. So that was the primary defense was, no. This was his employer. And so I guess the jury had to answer that question. Who was the employer or who was the responsible party for what happened?
Right. And it's interesting that you phrase it that way, right? Because that's one of the things that we discussed a lot with Judge Garcia at the charge conference, was exactly what that question on the verdict sheet was going to look like. And we prevailed on the idea that the jury doesn't need to decide who Justin Riegel's employer was. They only have to decide if they're convinced that Concert Philmont LLC was his employer. And so I did that in closing. I said, you don't have to decide. You don't have the weight. You don't have the burden. You don't have to decide who Justin Riegel's employer is. There's documentation and testimony all over the place. You don't need to make sense of it. All you needed to do is decide you don't think it's more likely than not that Concert Philmont LLC was the employer. But oh my God, I've never had stress, Brendan, in a trial in all my life as when the jury hit that question and we got an answer in our favor on that question. And after that point, I was like, I think we're in. I think we're getting a verdict.
So was that the first question?
It may have been. I think it may have been.
Because after that, if they go the other way, there's not really a point of answering any more questions, right?
Well, no, we took the position that, hey, the immunity really only would have applied as to Concert Philmont LLC, not as to the management company.
I gotcha.
So no, we were thinking the management companies independently should still go to the jury. But that, relates to the kind of the second fight and another important part of the defense, which was act of God. And boy, oh boy, did we hear act of God a lot.
Yeah, you had derecho comes in, which is, how many derechos have come through Eastern Pennsylvania before?
And so it turns out that was also a big fight, among the meteorologists. It's just how common this is. And what we wound up doing was saying, it's got a fancy name. And yes, I'd never heard of a derecho before this case. Maybe you hadn't either. But it's really just another name for a particularly straight, severe thunderstorm. Just a severe thunderstorm. So they had John Scala from the Weather Channel telling us that there hasn't been a derecho that hit that particular area of Montgomery County, Pennsylvania since 1952. And, we had a meteorologist on our side saying this is a severe thunderstorm. These hit all the time. And in terms of weather preparedness, it's really all the same. So that did wind up being a major fight. And again, going back to the charge conference with Judge Garcia, one of the things we worked on a lot is, should there, in addition to the employment question, right, which is an immunity question, and we thought there had to be basically a special interrogatory for that, should act of God be on the verdict sheet? And that was also something that the judge went our way on. We were able to keep act of God off of the verdict form, in large part because, and I didn't know this, it turns out in the Pennsylvania suggested standard jury charges that the concept of act of God is part of the concurrent causes charge, right? So the law on that is, even if there is an act of God, which is a contributing factor to a bad outcome, if there is also a negligence cause of the harm, then you can find those are concurring causes, and you can still find that there was negligence on the part of the defendant and make an award. So that was the basis on which we were able to kind of keep the act of God defense contained. But it also led, to go back to the focus group thing, it also led to something that I stole. I don't even know who the focus group member was, but I stole this directly from her or him, which was one of our themes, and I opened on this, which is acts of God can't be prevented, but sometimes they can be planned for. And it turned out, we did have a jury consultant helping us with jury selection. So we were doing background research on our jury pool members. We knew that we had wound up impaneling at least 3 people who really identified very strongly as Christians, and I knew who they were, and I'm kind of looking at them when I say acts of God can't be prevented, but sometimes they can be planned for. And I got, the three heads nodding with me that I was hoping to see. So again, something that came right out of the focus group that I don't know if I would have gotten there myself.
Did you, whether it was, with the consultant or I'm not sure how whether it was open voir dire or combination judge questions or so forth, but did you have a question trying to identify, people that were, fatalistic, very, God's plan type of thinking versus, no, things can be prevented that are foreseeable and so forth?
So not, in Philadelphia, we use a standard form that covers both, one side is kind of criminal law type questions, one side is civil law type questions. They're not all that terribly helpful. And in terms of questions to the group that we added, there really wasn't one on that issue. I think that, once we were then able to do some individual follow-up jury voir dire questions individually, and there were some with whom I tried to kind of get at that a little bit more. Obviously, you see somebody wearing a cross, wearing a Star of David, what have you, somebody who's kind of outwardly identifying religiously, try to be very, very careful about that, but trying to maybe ask a question that kind of goes to that sort of an issue. Yeah.
So, three big hurdles. You've got, the relationship paternity issue. You've got, this employment, multi-corporate entities, who's in control issue. You've got this act of God issue. Is it, did this come out of nowhere, wasn't foreseeable versus it was foreseeable, battle of the meteorologist? Any other hurdles that you guys had to overcome before we talk about some of the good evidence you had going for you?
Wow. Yeah, I mean, those, in a way, those three weren't even the worst. The biggest problem was the tree was healthy. The biggest problem was the tree was not diseased, was not decayed. There simply wasn't any evidence that the tree was unhealthy. And so we wound up needing to reframe the thinking about the tree by saying a tree can be two things at once. It can be healthy, and it can also be a hazard. And the key to doing that really came from our expert arborist, who was the first to sort of say, Dave, you go down the shore, right? You understand this in Philadelphia. We don't go to the beach. We go down the shore. Brendan, right? You get this?
Sure. Oh, yeah, I've heard it.
The shore is the Jersey Shore, just so we're clear about this. He said, you go down the shore, and who are the people that irritate you the most? The people that don't spend the time to actually really get their beach umbrellas dug in and secure. He says, this tree, which was very, very much overgrown as a pin oak tree, had this unbelievably large canopy, and that canopy was a sail. That tree, basically, in the right wind, it was a beach umbrella. It was going to come up and it was going to start toppling over on stuff. And that's 36,000 pounds of healthy tree coming over onto a high volume area at the club with an amazing amount of force. So that wound up being, I think, probably the most difficult hurdle to overcome, because for the 2+ weeks that we tried the case, the defense kept talking about it was almost like kind of a Donald Trump rally refrain, this big, beautiful, healthy tree. And I think that they were maybe not completely ready for our pivoting and agreeing with them. It was a big, beautiful, healthy tree, but it was also a hazard tree. Here's why.
Well,
And that's where we went.
I think that analogy is awesome. Taking it to, that the beach umbrella that everybody's, held their breath when they see one, it was fine. It was in the sand and now it's turned into this projectile spear flying down the beach, and then comparing that to the tree. And, you were kind enough to share with me the whole pretrial statement, which was really laid out well with all the photographs. And I mean, you've talked about the size of this tree, but, again, picture's worth 1,000 words. This tree was absolutely massive, and it was right in the middle of where all these buildings were. I mean, it was almost overarching like everything. So, I mean, while it was beautiful and was probably the centerpiece for the club, you could see how it was healthy, but, also it was a danger. And anybody kind of looking at this could say, boy, what if this thing fell over? What could happen? Fortunately, on top of everything else, you guys had some pretty good evidence that they knew it was not just a healthy tree, and maybe it could pose a danger. Can you talk about some of the good evidence in the case, that probably helped seal liability?
Well, it's interesting. Actually, I kind of think that the best evidence about the tree kind of came through concessions made by the defense tree expert. The defense arborist was not an effective testifier. He said right off the bat, he didn't like testifying. He didn't do it much. Most of the cases he worked on settled. He didn't have any desire to be talking to a jury, and he wasn't good at it. But he was a remarkably honest guy, and really kind of conceived of himself as an expert, an advocate for his expert opinions, not an advocate for one side or another. And what he wound up saying, what we put together, were a couple of things. One was that this tree sat on the practice putting green. And because the tree threw off so much shade and acorns, the practice putting green was constantly it was like this, the superintendent staff was constantly working on this practice putting green to keep the acorns off, etc. But they were also like supercharging the area as part of the irrigation system. And so they have this very, very fancy weather system. They're measuring all sorts of environmental conditions and meticulously, aggressively watering the area, and then being frustrated that this damn tree keeps stealing all the water and all the nutrients that's supposed to be feeding the turf. And that, in combination with the defense arborist expert saying, this is a super, super healthy tree. In fact, it's kind of amazing how much it grew after it turned 50. We don't see pin oaks continuing to grow in this way. Like, so once it came over, we were able to see the rings. He was saying, you don't see this kind of growth on pin oak trees of this age, because this tree is probably about 100 years old. And even in its second 50 years, it continued to grow like a young tree. And I was saying, yeah, that had everything to do with the fact that it was right there at the heart of the superintendent's irrigation efforts, and that basically this was an overgrown, overwatered tree, which fit with the concert golf corporate narrative that the Philmont Country Club members who originally owned it and then sold it in 2017 to Concert Golf had just deferred maintenance, deferred maintenance, deferred maintenance, deferred maintenance. So by the time that we get to 2020, you've got this massive canopy on a tree that has been growing the past 50 years at a rate it's not supposed to grow. Nobody has ever done a tree risk assessment or assessed the tree. The canopy's actually growing over the cart barn. And then if you look real carefully, and you take a protractor, a ruler, what have you, you can see the flagpole, you can see the wall of the cart barn, and then you look at the tree, and the tree's leaning toward the cart barn. So we get them to acknowledge this is a high traffic area. This is an area that everybody comes through. They get their cart, they warm up on the putting green, they go to the driving range. Very, very high traffic area. You've got this tree that's leaning, and the tree is also completely by itself. It's not protected from the wind by any other trees. And so we began to talk about the cart barn as being this sort of high pedestrian traffic area right next to the clubhouse itself, toward which the tree is leaning. It's also downwind of all the major storms, and nothing is protecting this tree, and it's already leaning right. And so when you put all that together and you say you've got this high traffic area 23 feet away, and the high traffic, high pedestrian area is right directly in the target zone of where the tree's going to fall if it does fall, that's how we began to put together a sort of comprehensive picture of it can both be healthy and also be a hazard.
That's a lot of hoops, though, that you have to jump through.
Man, I feel myself.
It's not very straightforward,
arguing
I'll
this
say.
to you, and I'm like, oh my God, the jury must have been like, wait, what?
Tell me about your good evidence, Dave.
Yeah, really.
No, but clearly, over that 2-week period, you guys were able to layer in, and build, kind of that mountain of evidence showing, in a sense, it was inevitable. But another thing that comes to mind why this was difficult is the fact this tree had been there for 100 years and hadn't fallen over. You know what I mean? Like, what are the chances it just happened to fall? I mean, just kind of more, seeming act of God in favor of the defense. All those different factors that you talked about. I mean, were there any offers of, of settlement, if you can talk about it? Or, was there something, but it just was woefully, inadequate?
No, nothing.
There had to try case.
There was not a. In fact, I think my opponent, Jack Snyder, I think that's what he told the legal intelligencer after the fact. Some cases just have to be tried. So no, let me give you the complete answer to that question, Brendan. There was not an offer at all. But what did happen was that after we closed and Judge Garcia charged the jury and the jury went out, the defense lawyer texts me and says, the excess carrier wants to talk with you. I said, okay, great. I talk with the excess carrier in Bermuda, and they say, we just don't see the case the way that you do. We don't think there's any chance of settling the case. To which I'm thinking, okay, nice, but pleasure to meet you, but I don't know why we're talking. He says, but are you interested in a high-low? And so that was the point, that afternoon was the point at which, while the jury was out, we were able to negotiate a high-low and then go back to Judge Garcia and put the high-low on the record. And, in terms of trial points for our respective students, that's really, really important. If you're going to do that kind of a side agreement, then it is hugely important that it be formalized, and if you don't have time to do a writing, the way to do that during trial is get the judge, get a court reporter, put it on the record so that it's very, very clear. And I don't know the sophistication or experience level of our audience. Should we just talk for a second about what a high-low agreement is?
Yeah. In fact, I wasn't expecting to get into this because I didn't know there was a high-low.
Yeah.
But this has actually been kind of a hot topic in my office lately. Maybe over the last 4 to 5 years, I've essentially had 3 different scenarios with high-lows, and I'd like to hear what you think about when you're considering a high-low. I'll give you my 3. Had one high-low, my clients rejected it. We got a verdict. Excuse me. They took it. We got a verdict above. They're stuck with the high, and they were annoyed. Mm-hmm. Okay. Had another one, high-low offered, rejected it based off of big data that we had, and wound up crushing it. Thank God we didn't take it. Mm-hmm. Had another one more recently, high-low offered, very good money, Was thinking though that the case, if it hits, is worth a lot more than the high. Reject it, we lose, we get nothing. And that last one in particular made me really rethink how to think about high lows. And I'd like to understand from your perspective, you're in that case, there's been nothing offered so far. Why don't you first tell like just the basics of what a high low is, how it works, and then what do you think about whether this is a good deal for your client or not?
Yeah. So very basically, a high-low agreement is an agreement that even if there is a defense verdict, that a certain minimum payment will be made. On the other hand, if there is a massive verdict, the high will limit how much actually gets paid. And then if the jury comes back in between the low and the high, then the case will essentially settle for whatever that amount is between the low and the high. I would say overall at our firm, we're pretty big fans of high-low agreements. And in a case like this, where we knew that we were going to be able to sock away a very substantial amount of money for Justin and Kate's child, especially since the child's only 4 years old and there'd be plenty of time for that money to grow, our thought was it would be sensible to manage risk on our downside, even if that meant that if we had a big hit and we got a very large verdict, that we would be limiting the amount that we actually collect. And so I explained this to Kate and to Yvette. I think that they understood the parameters of what it meant. I think they were feeling at that time, it wasn't clear during the trial that we were winning by any stretch of the imagination. So I think that they were in that moment very happy to lock in a certain amount on the downside, even if that meant on the high side maybe not getting as much money as we could have. And so this was a situation like you described, where the verdict came in, substantially above what the high was. And that's okay. That's okay, because the high is still a number that we agreed to, and it was a number that we agreed to because we were getting a low that was acceptable to us. So I feel this was not something that I pushed. This was something that I presented and explained. I certainly didn't think it was wrong for my clients to accept it. It made sense to me. I did run it by my partners. My partners were in favor of it. And, what I said after the verdict, both to the excess carrier guy in Bermuda and also to my opponent, I said, from a certain perspective, look, we all managed our risk. We all did our jobs. That's what we were supposed to do. And, so I get this nice verdict. I get invited onto Brendan Lupetin's, fancy
Lucky you.
podcast, get, a little bit of attention in the press. So, you still kind of get the benefit of having had a verdict and still plenty of money, I think, for the family. And that's probably the important thing.
Well, and I think one of the big, one of the key points that you touched on there that has, now my caveman brain has started to figure out is managing the downside risk. And I think I've gone through my career, and I think a lot of plaintiff lawyers, we don't, like, the defense is all about risk. Mm-hmm. That they're all about the risk assessment. And on our side, we're really not as much, generally speaking. I think, to be a trial lawyer, plaintiff's trial lawyer, contingency based, I don't know, you kind of have to be less risk averse, less risk weary than your average person. However, when you get into that situation, it's, your responsibility to, present the best options for your client. And if there's a substantial amount on the low that is, like you said, going to help, manage that downside risk, it's something you really have to focus on, I think, more than, well, what if we hit the home run for these people kind of thing. And
yeah, and along those lines, remember, in terms of the case, thematically, I'd already been jumping up and down in that courtroom for 2 weeks, screaming that Concert Golf never did a risk assessment on the tree. Right. And I don't know, maybe this comes from my first 8.5 years as a defense lawyer, but I still think in terms of where the numbers look okay, managing the risk with and for the clients. And so, yeah, I felt very, very good about the high-low. And yeah, so we're not collecting ultimately the entire amount of the verdict, and so be it. I think it was good judgment. I do.
Well, let's talk a little bit about, the amount of the verdict, kind of where it came from, and sort of another hurdle that I perceived, which was it appeared that Mr. Riegel, fortunately died quickly. It looked, he died at the scene, but there's that issue of, is there evidence of conscious pain and suffering, because how that can factor into an award in a wrongful death survival claim. So can you explain to us kind of what happened there? Was there evidence of conscious pain and suffering that you're able to get in, and then did the jury find in favor of that or not?
Yeah, I think, to answer your last question first, that was an area that that was a claim the jury was less impressed by. We presented a forensic pathologist to talk about the manner of death, and based upon the manner of death, the forensic pathologist that we hired gave the opinion that there was a mechanical asphyxiation, which is not an immediate kind of a kill shot. The defense forensic pathologist took a very different view based upon the pattern of skull fractures, gave the opinion that there would have been, Justin Riegel would have been immediately knocked out and would not have been conscious, as he was unable to catch a breath and unable to breathe. So even if he might technically have been alive for a little bit longer after the tree came down through the cart barn roof, this idea that he would have been knocked out immediately and as a result would not have experienced conscious pain and suffering. And I did a very, it's a little bit mortifying to think back on it. I did a very dramatic, very active cross-examination of the expert, kind of making fun of him for harping on this idea that, as people from the club were calling out for Justin, they didn't hear anything, he didn't seem to be responding, blah, blah, blah. So I do this whole bit in the cross-examination about how loud it must have been, right? Because the cart barn itself has garage doors on the north end and on the south end. You've got these winds that their expert is saying are 83 miles an hour. You've got alarms sounding. You've got this wind whipping through. You've got trash flying up everywhere. And I kept saying to the defense expert over and over, how many decibels? What was the volume? What could you hear, to try to diffuse the argument that nobody who was calling out for Justin heard any evidence of his being alive. But ultimately, the jury kind of saw through that part of the theater. I think that they figured, there may have been a moment or two during which he did experience some conscious pain and suffering, but it was thankfully very, very brief. And I have a favorite case, and I teach this, Brendan. If you don't know it, it's a wonderful one, Byrne versus Moad. and it says that in Pennsylvania, the period of time for conscious pain and suffering may be seconds or even fractions of a second, but if proven, it's still recoverable. And so I wound up actually using that. I actually cross-examined the forensic pathologist. He was from Kentucky. He is not licensed or boarded in Pennsylvania. So I did a little bit of a, you Kentucky outsider kind of shtick, and kind of, read to him the law in Pennsylvania as part of the cross-examination. And he was very good, and he really didn't flinch or bend. He was like, no, instant unconscious, no conscious pain and suffering. But I did get in the point that the jury was allowed to consider conscious pain and suffering, even if it was for a very, very limited period of time.
So how did the verdict break down from a damages perspective? And actually, who did they allocate fault to? And then, how did the damages break out?
Well, so remember, we worked very, very hard with all of these Concert Gulf corporate entities. We worked very hard just to slim it down to 3, right? As I said, we had the property owner, and then we had the manager up until August 2019, and then the manager since that time. And once we got past the employer immunity question, the jury allocated 1/3 to each of the defendants,
Okay.
which was kind of sort of a straightforward and reasonable way to handle it. So the allocation is to the 3 defendants who were actually on the verdict sheet. Each of them was responsible for 1/3. And then, the only beneficiary here, because Kate and Justin were not married, is their child. And so what wound up happening was the jury awarded pretty much exactly what our economist said the wage loss was, or loss of earning potential was, and what the loss of household services was. We got those numbers pretty much on the nose. And then we got the 100 for conscious pain and suffering. And the big award, I think it was 6 or 6.5, was to Justin's child. And on that, I really focused in my closing on all of the lessons that Justin and Kate's child would not have being taught by Dad. And that, oof, man, oh man, oh man. That's like, as a trial lawyer, that's where it gets hard not to become emotional, because of course, how can you not be emotionally invested in that? So that's where, the bulk of the award actually was that loss of guidance and tutelage, I guess we call it formally.
Before we went on, you teased or alluded to when I was mispronouncing the name, Justin's last name is Riegel.
Oh yeah.
And you explained it was Riegel, and you said that had something that came up somehow in the trial. What were you talking about?
This is mortifying. This is mortifying.
This is why I had you on the show.
Oh my God, so bad, so bad. Jack Snyder is a lawyer who, in Philadelphia, southeastern Pennsylvania legal circles, is legendary. I mean, he has been one of the top defense trial lawyers for decades. And his name is spelled Snyder. I've always known him as Jack Snyder. And in the second week of trial, I see Jack take my associate, Mike Z, aside, and I think I hear what was said. Apparently, Mike Z had been referring to him as Schneider, but I missed it. I thought that what Jack was saying was, actually, it's Schneider, not Snyder. So I'm like, oh my God. And there's a longer story, but there's another defense lawyer in town who I don't know, 10, 15 years ago at a trial, corrected the manner in which I pronounced his Irish name. So I'm very sensitive to this. And of course, my last name gets mispronounced all the time. You probably have like a similar, you probably get some mispronunciations
Oh,
yourself here
sure.
and there. Yeah.
Absolutely.
So I'm running around the courtroom thinking, oh my God, I've been saying Jack's name wrong all these years. And I start calling him Schneider, 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 Schneider. So I am doing that. I close, he closes, I get back up for my rebuttal. In my rebuttal, I start with the Schneider, and he stands up and he says, I'm sorry, I just can't take this. It's Snyder, it's not Schneider. And the jury is laughing. My wife, my some of my colleagues are beginning to, I think my wife wanted to die, are looking and laughing, and I'm like, oh my God. So I had to apologize to Jack. It certainly wasn't strategic on my part. It was just idiocy. But I thought I'd specifically heard him correct my trial partner.
And meanwhile, you're in the middle of your rebuttal.
Yeah, I'm trying to, this is supposed to
Can't
be
give him too much
rebuttal,
context
but
in the
I
moment.
save my time for, right? And and instead I need to pivot, turn around, and actually apologize to him, completely undermining the force of my rebuttal. So that is, I know in my household, a moment in my trial career that will live in infamy.
Hey, man, I think there's actually a lot to be said for weird little moments like that from a, humanizing and credibility perspective, because I can, tell in my limited interactions with you, how you would have responded, and you would have shown Snyder like genuine, like, oh my God, I'm so sorry, and I think, and that wasn't calculated or contrived or anything. It was just like a natural reaction, and the jury laughing. You know what I mean? Like, I almost think sometimes if you can find a way, to apologize to the jury about something that you did, I mean, you shouldn't do it as, if it's just a complete, gimmick, but that can help, with their perception of you, that you're not just some, jerky trial lawyer, and you're just, fairly regular person who makes mistakes and owns up to them.
Yeah.
But yeah, that's great. All your momentum just gets sucked out of the room at that point.
Really, pop.
Yeah, but again, like I was saying, I mean, that's one of the great side, silver linings or side aspects of being a trial lawyer, are all the great stories that you remember and get to tell for the rest of your life. So, well, Dave, this was awesome. Learned a ton. Really cool hearing how much more of a complicated case than it appeared on first blush. And really, I think some of the big takeaways are the nuanced way in which you, dealt with the defenses. Okay. It was everything that you talked about was not just like, it's not this, it's that. It was, yeah, it's this and that. You were able to kind of take what the focus group had, or use your own, I think, ingenuity to make those more nuanced arguments, which I think a lot of times are much more compelling to the jury because they're kind of packed with credibility, because you're sort of accepting the reality of it, and you're just showing, yeah, but it's just a little bit different than that. And I think people can see that better. And obviously great lawyering, which is no surprise why you end up getting a great verdict. So congrats, man, and thank you for agreeing to talk to me about the case on the show. Really cool. If people want to get a hold of you, they want to talk to you about some gigantic crane falling over or other construction disaster or something, because you were the man at those cases. What's the best way for people to get a hold of you, Dave?
I think it's pretty easy to get hold of me. Last name obviously is Kwass. Probably the easiest way is email, which is dkwass at smbb.com. But if you give me a Goog, you get my office line, you get my cell phone, you get me in any way you want me.
And then you'll get to read his bio, and we didn't even touch on this, that he was a former band member, the original Dave Matthews Band, which my wife's going to kill me that we didn't get into. But
I'll come visit you in Pittsburgh. We'll go out and we'll talk about it.
We'll leave that teaser. We'll leave that teaser for my small audience to go dig into. So, Dave, thanks again, man. Congratulations, and hope to see you soon.
Brendan, thank you so much. Appreciate being on the show.
If you enjoy the show, please subscribe to the Just Verdicts podcast on your favorite platform and consider leaving a review. And if you're interested in co-counseling, local counseling, or referring a catastrophic injury case, we'd love to work with you. Call us at 412-281-4100 or visit our attorney referral page at pamedmal.com/refer. Thanks for listening.